I'm Paul Menace. I co-head entertainment and media for Adley Law Group. And at the intersection of entertainment and media are my social influencer clients. So today I'm going to talk a little bit to social media influencers about some things I think you need to know and some best practices so you can grow your audience and stay out of trouble. So whether you're a micro-influencer or a huge influencer with millions and millions of followers, there are ways to increase your revenue and grow your audience. But to do that, you have to know how to effectively monetize your channel and your other social so that you stand out. And you also have to know how to protect your valuable intellectual property, which is your copyrights, your trademarks, basically your name, your face, your likenesses, your persona. If you have a logo, that should be protected also, because that's what generates your income and that's what makes you a prominent influencer. So probably the first step I advise my influencers is to form an entity. It doesn't matter if it's an LLC or a corporation or a limited liability partnership, because they all protect you legally pretty much the same way. Probably the second most important thing is protecting your content, as I mentioned. This is your trademarks and your copyrights. The good news is, for copyright protection, you don't need a lawyer to help you. You can protect copyrights by registering them. This can be done online at the U.S. Copyright Office. It's designed for non-lawyers. Takes about 20 minutes. You can register multiple copyrightable subject matter on one application, and depending on how many works you're registering, it's about $55. The benefits of registering copyright and trademark is it prevents other people from using it because you own it, and it allows you to sue for damages if you're infringed. It allows you to get attorney's fees if you win, so that's a disincentive because the other person's got to pay your attorney's fees and their attorney's fees. And it also allows you to get certain kinds of damages in federal court that you wouldn't otherwise be able to get without registration. It's also public notice when you register that the stuff is yours and people shouldn't use it. And there's also some reciprocal benefits in foreign countries. Another area which is super important is properly disclosing endorsements. Now that brands are more willing than ever to pay influencers to promote their products or services, and not just influencers with millions or tens or hundreds of millions of followers, but also micro-influencers, which is usually about between 5 and 20,000 and up followers. You have to, because more of this is happening, it's incumbent on you as an influencer to understand about disclosing endorsements. So the Federal Trade Commission is in charge of this, and they've ramped up enforcement of the Federal Trade Commission Act, which is the basic act in the US about truth in advertising. And the act must be followed by influencers so they don't run afoul of it. And the FTC's been cracking down quite a bit, even been suing influencers. So knowing how to properly disclose endorsements, very, very, very important. The next subject I want to talk a little about is having rock-solid contracts. There's a big difference usually between the deal you think has been made for you or the one you've made yourself and what winds up on the written contract that's eventually signed. And it's the written contract that governs. You don't want to sign an agreement that winds up paying you less money than you thought and imposes more obligations on you. So how do you avoid these kind of problems? It's simple. The contract should be written in clear, concise, conversational English. Some other advice I can give you is don't negotiate your own contracts. You shouldn't do that any more than I should endorse something on social. And the reason is the contract was written by a lawyer, and there are terms in that contract that have special legal meaning that you won't be aware of, and therefore you will not know how this can affect you and your obligations under the contract. The next quick topic is infringement. It amazes me how many people, including C-suite executives, don't really understand that just because something's sort of out there in the ether, they can use it without having to get permission or to pay for it. A lot of the platforms like YouTube have free music libraries. YouTube also has a thing called the Music Policies tool that identifies whether certain music is licensed or pre-cleared so that you can use it in your videos for background. Last but not least, I want to talk about artificially building your audience with bots. Really lousy idea, because the federal government considers it both false advertising and they've been investigating this kind of as an adjunct of the commercial and political abuse of fake accounts online. So don't use any of those services. Don't let your PR firm or your manager or anybody use any of those services to build your audience and to make more money. You got to do it organically, and if you follow some of the things I've mentioned, you should be able to do that. So if any of you have any questions or want a little more meat on these bones, please don't hesitate to reach out to me. Thank you.